Get ready for the dictation. Start. Heard learned counsel for the parties. Petitioner, by means of these applications under section 482 of the Code of Criminal Procedure, has invoked the inherent jurisdiction of this court with prayer to quash the order dated 26/8/2013 passed by ad hoc additional sessions judge 4th Jamui in criminal revision number 5 of 2012, whereby the order dated 16/9/2011 passed by Chief Judicial Magistrate Jamui has been affirmed, and to quash the order dated 16/9/2011 passed by Chief Judicial Magistrate Jamui in case number 285C of 2011, whereby final form submitted against the petitioner has been accepted. The contention of the learned counsel for the petitioner is that the order impugned has been passed without giving opportunity of hearing to the petitioner. The order has been passed in absence of the petitioner, which is illegal. As such, the order dated 14/9/2011 is fit to be quashed. Learned counsel, in support of his submissions, has relied upon the judgment of the Honorable Apex Court in the case of Bhagwant Singh versus Police Commissioner, reported in AIR 1985 SC 1285. From perusal of the materials available on record and looking into the facts of the case at this stage, it appears that the arguments advanced by the learned counsel for the petitioner has force. While order dated 11/11/2013, a report was called for from the court below as to whether Manoj Singh, son of Khiru Singh, who was shown to be witness on the notice, is a resident of village Aliganj, PS Chandradeep, district Jamui or not. Report dated 2/5/2014 is on the record, which shows that he is not resident of the aforesaid village. As such, there is no valid service of notice. In light of the judgment of the Apex Court in the case of Bhagwant Singh versus Police Commissioner, reported in AIR 1985 SC 1285, notice to the informant is necessary. In view of the above, the impugned orders are not sustainable in law and are accordingly quashed. The matter is remanded back to the court below for passing the order afresh in accordance with law after giving opportunity of hearing to the petitioner. Since petitioner is before court, no fresh notice is required to be served upon him. The application accordingly stands allowed. Feeling aggrieved by the judgment and order dated 15th March 2010 passed by the learned single judge in above CWJC number 2071 of 2007, the respondents, State of Bihar and others, have preferred this appeal under clause 10 of the letters patent. The respondents, writ petitioners, are the dependent children of the government employees who died in harness. It is not in dispute that the deceased parent of each writ petitioner was an assistant teacher in a government school. Each such assistant teacher died in harness. The claim of the writ petitioners for compassionate employment in government service was considered by the District Compassionate Appointment Committee, during the year 2002 and 2003. The committee, in respect of the dependent members of the deceased assistant teachers, recommended that such dependents be appointed as assistant teacher in government schools. Pursuant to the said recommendation, some 11 persons were appointed as assistant teacher in government schools. We are informed at the bar that the said persons are still serving as assistant teacher in the government schools. Nevertheless, in spite of the recommendation made by the committee, the petitioners were not offered compassionate appointment. The petitioner approached this court under Article 226 of the Constitution in CWJC number 14391 of 2004 by judgment and order dated 6th April 2005. The learned single judge was pleased to allow the said petition. The appellants were directed to appoint the petitioners as assistant teacher in government schools as recommended by the committee. The said judgment was challenged by the State of Bihar in letters patent appeal number 697 of 2005. By judgment and order dated 3rd January 2006, the division bench was pleased to hold that the petitioners did not possess the minimum qualification prescribed by the National Council for Teachers' Education. The petitioners therefore could not be appointed as teacher on compassionate ground. The bench further held that the recommendation made by the committee did not create a vested right to appointment on the post recommended by the committee. Stop.